not even a subject matter of this court, or a recommendation must be made for consideration by the legislative body. The court has left it, my lords, to the legislature. Considering, my lords, we assume the historical background, the high constitutional status which privileges themselves have occupied in constitutions all over the world. Then, my lords, page 15. What has Parliament felt, my lords? Because after all, the criticism has been voiced over the years, my lords. And this is always a vexed issue. Parliamentary Standing Committee reports, the relevance of which was recognized by this Honorable Court in Kalpana Mehta, are documents that reflect parliamentary oversight. 48th report of this committee of the Lokpal Bill was tabled before both houses of Parliament on 9/12/2011. Section 17 of the Lokpal. Section 17 of the Lokpal Bill, which related to the jurisdiction of the Lokpal, contained a subsection 2, which prevented the Lokpal from inquiring into any matter connected with the allegations of corruption against any member of either House of Parliament in respect of anything said or a vote given by him in Parliament or any committee thereof covered under the provisions contained in Clause 2 of Article 105 of the Constitution. A perusal of the 48th Committee report indicates that the committee had indeed extensively discussed the need to omit Section 17(2) from the bill so that the Lokpal could indeed inquire into allegations of corruption against MPs. In this context, my lords, of vote given, and the following was the outcome of the said discussion. The committee itself observed that Article 105 did not provide MPs immunity or protection from disciplinary proceedings or sanctions initiated and conducted by Parliament itself. A reference was in fact made to this Honorable Court's verdict in the Raja Rampal matter. B. Vote, conduct or speech within the House was intended to promote independent thought and action without fetters within Parliament. The immunity for vote, speech or conduct within the Houses of Parliament does not in any manner leave culpable MPs blameless or free from sanction. In fact, they are liable to and have in the recent past suffered severe parliamentary punishment, including expulsion from the Houses of Parliament for alleged taking of bribes amounting to as little as rupees 10,000 for asking questions on the floor of the House. Certain oft-cited instances of expulsion of MPs and MLAs for alleged breach of parliamentary and legislative privileges are as follows. A, my lords, I have given Mr. A.J. Mudgal's case. Then, my lords, B, my lords, Mr. Y.R. Meghawale was expelled by the Madhya Pradesh Assembly for assaulting the Deputy Speaker of the House. That expulsion was affirmed. C, Mr. Subramaniam Swamy was expelled from the Rajya Sabha in the context of the events of the emergency, my lords. D, Mrs. Indira Gandhi was expelled, again in the aftermath, my lords, of that very period. Then, my lords, Raja Rampal. So there are instances. Now, my lords, come to the next part of the submission, my lords, the unintended consequences of further refining the law.
Yes.
As stated, para 22 minutes. Earlier herein, the purpose of the immunity conferred under Articles 1052 and 194(2) was never to create a class of super citizens, but to insulate MPs and MLAs from the might of the executive. Can I just pause here a minute? Super citizen is a concept which was very much present before the court in Narasimha Rao also, because when you're talking of privilege, analogy which comes immediately to mind is super citizen, but all constitutional immunities, immunities to governors, immunities to the president, in that sense, because they are a class apart, they are treated differently. was never to create a class of super citizens, but to insulate MPs and MLAs from the might of the executive. Votes given and speeches made in the legislature usually relate to matters proposed by the party in power, and every such party would have a natural desire to eliminate as much opposition as possible, or at the very least cause a sense of fear among opposing legislators. The parliamentary privilege and immunity conferred upon MPs, MLAs, if further whittled down, would only enhance the prospect of abuse of the law by political parties in power. The following hypothetical yet very probable examples seek to illustrate this submission, assuming that this Honorable Court declares criminal offences by legislators being unprotected by Articles 105, 194(2), even if they relate to votes made or speeches given in Parliament or legislature. First instance we are given minutes is a case of bribery. A political party X enjoys a very thin majority of 7 seats in a legislative assembly, 5 of which are filled by independent MLAs. The opposition parties form an alliance, and this alliance declares its intent to introduce a no confidence motion following the unearthing of a scam. Given the sensitivity of the issue, the Speaker is constrained to grant leave for. Given the sensitivity of this issue, the Speaker is constrained to grant leave for discussion and voting on the motion. During the voting, 3 out of the 5 independent MLAs vote in favor of the no confidence motion, despite which X barely manages to prove its majority on the floor. Embarrassed by the negative votes of the said 3 independent MLAs, the leader of X lodges frivolous FIRs against them, alleging that they had voted after having agreed to take bribes from the opposition party. The MLAs are consequently arrested, and by the time they are able to procure bail for themselves, they miss out on debates or other important bills which were laid before the House during their absence. But if the court is to take cognizance of reality, as the court does, always, if political corruption is a fact of life, misuse of the law is equally a fact of life. And this court has often come to the protection of either ordinary citizens or politicians who have suffered unjust prosecution, intimidation at the hands of agencies of different state governments, irrespective of their political hue.
Therefore, should we grant, therefore, immunity to political corruption on the apprehension of a misuse of law?
No, with respect,
because an apprehended misuse of law is always amenable to protection within the court.
No, my submission is slightly different, Mills. My submission is that since this apprehension of misuse has been at the root of the very grant of privilege and immunity from historical times, it's not that the court is today giving some fresh chit or blanket of immunity. The fact of misuse of persecution by the powers that be is a historical fact of life, whether by powerful monarchs or by powerful executives or even by weak executives in order to survive. Therefore, the court is only being asked to continue what has stood the test of time. Minutes, I give another example of a hate speech. I don't need to read it out, minutes. There can be myriad examples, minutes. Then, minutes, kindly Come to para 25 at page 20. Before that, para 24. Indeed, it does not require much effort to think of other hypothetical examples of adverse consequences of truncating the already truncated ambit of parliamentary public legislative privileges. While these examples are hypothetical, no doubt, what is not hypothetical is the fact that legislators would be extremely cautious, if not wary, to make statements or give votes against the ruling party in the event the immunity conferred by 1052 and 194.2 is chiseled even beyond its present form, exposing legislators to prospects of criminal proceedings for votes made or speeches given in the legislature merely to equate legislators to common citizens of the country would only result in them performing their legislative duties with fear and fetters as against without fears and fetters, which was the original intent of legislative privilege in the first place. And my lords, if the concept of chilling effect, which your lordships have applied in the context of freedom of speech to ordinary citizens, the concept of chilling effect, my lords, must equally apply in a context like this, my lords. Minutes, para 25, under the heading minutes, addressing the paradox within inverted commas in the P.V. Narasimha Rao judgment. One of the criticisms of the P.V. Narasimha Rao judgment is the paradoxical situation that it has resulted in. An alleged bribe taker who had abstained from voting was not granted immunity, while the others were, who had actually voted in favor of the bribe giver, were granted the said protection. While this paradox may, on the face of it, sound ironic based on seemingly unintelligible differentia between persons of the same class, one does not need to address the following concerns. One does need to address the following concerns before overruling the ratio of P.V. Narasimha Rao on this ground. Firstly, A, this paradox was a result of the reading of the very text of Article 1052, which confers immunity for a vote made or a speech given by a legislator. A vote not made or a speech not given would, even by the principle of expressio unius, stand excluded from the purview of Article 1052. Secondly, a constitutional principle resulting in a paradox does not necessarily mean that such a paradox is not constitutionally permissible. The paradox in the instant case merely results in limiting the scope of immunity conferred under Article 1052. As observed by this Honorable Court in Anuradha Basin, albeit in the context of a constitutional right as against a constitutional privilege, such a limitation is certainly permissible as there is no other alternative measure that may similarly achieve the mischief that Article 1052 seeks to address, that is, insulating legislators from being oppressed by the power of the Crown. Paradoxical instances are not unknown to constitutional law in any case. The very fact the right to vote is not a fundamental right, even though democracy is part of the basic structure of the Constitution, is in itself the hallmark of a constitutional paradox. 27. It is submitted that the majority view in P.V. Narasimha Rao was aware of this dichotomous result, despite which it laid down the law that it did. The reason for this is certainly not far-fetched. Setting aside a constitutional privilege merely to appeal to what seems logical, inverted commas, would indeed be antithetical to constitutional principles, particularly when setting aside the said privilege may lead to catastrophic consequences in the democratic process of the country. I have minutes covered 2 to 5 of my bullet points in my submission so far.
Yes.
Now, what remains for me is only to refute the argument of the CBI that voting in the Rajya Sabha election is not the sort of vote contemplated under 105 or 194. Sorry, minutes. In my zeal to stick to time,
Yes.
though there is still time minutes, I omitted to point out two things minutes before I come to this last part. Minutes. Pages 8 and 9
Of the same submission.
of the same submission. Minutes. Without reading in detail, I'll just draw the court's attention. 11 I'll read out, 12 I won't read out. Minutes. It's in Kerala Assembly case. Minutes.
Yes.
Where the judgment was authored by my Lord the Chief Justice. Minutes.
This is my judgment, right?
Yes,
Indian.
perfect.
Where they threw furniture at each other in the Kerala.
Parliament minutes.
Caused a damage of 2,22,000. But see, I mean, constitutional principle emerges on seemingly small cases.
Here there was throwing millions of objects. In central parliament, millions, a member of parliament brought a spray gun, millions, and sprayed pepper, millions. Parliament, millions.
Bifurcation of the state.
In the context of bifurcation of this is to the leading industrialist of the state, millions.
Yes.
Page 8 minutes. Yes, I refer to Ajit minutes. And I just want to read out from the summary of the principles which your lordships have culled out from Narasimha Rao minutes.
Okay.
A. Immunity was granted to the legislators in the PV Narasimha Rao case since the connection between the alleged conspiracy, the bribe, and the no confidence motion was explicit. B. Given the principles of constitutional supremacy in India, this court does have the power and authority to determine if a particular case falls within the ambit of Articles 194(2) and 1052. C. The purpose of bestowing privileges and immunities to elected members of the legislature is to enable them to perform their functions without hindrance, fear, or favor. D. The first limb of Article 194(2), which provides absolute immunity to members of the Legislative Assembly, is a manifestation of the freedom provided in Article 194(1). Then, para 12, courts in the UK and Canada have, post the Narasimha Rao judgment, followed a similar approach when confronted with issues pertaining to parliamentary public legislative privileges. A necessity test has been uniformly applied to ascertain whether the immunity sought to be invoked was necessarily connected with legislative functions. Then, given instances of all those cases of different jurisdictions, I won't read, minutes. Yeah. Which one? And there's only one expression, minutes, which I want to draw attention to because I've plagiarized that expression, minutes, in my submission. So I'll just read that, minutes. Page 10, bottom. Interestingly, two learned judges, while giving a minority, held that parliamentary privilege was not an exception to the rule of law, rather a distinct pillar of the constitutional architecture. That is what, Millets, I have plagiarized, Millets, in para 2 of my bullet points. Millets, finally, whether a Rajya Sabha election is different in character from voting on a bill or voting on a motion of no confidence or voting in a committee of parliament.
This could be on merits. Would it really arise on the
No, it is necessary for this reason.
Actually, that was because the learned attorney raised
That's
it.
it.
Would you like to then just defer it with the attorney doesn't raise it? We don't have to.
in any case, this is answered by a separate 5-judge bench in Kuldeep
No,
Nair.
I'm dealing with Kuldeep Nair.
So
Because
therefore, I mean, if the correctness of that view is not before your, I'm just flagging it for your lordship's consideration.
no. In fact, I am dealing with Kuldeep Nair here.
Mr. Ramsey, you can summarize that in 10 minutes. You've really held to time, so I'm sure we can give you those 10 minutes to look at this. This is the last point you're making.
I had said beyond lunch minutes, but then
Very fair, actually. And you can wrap up in 10 minutes.
I will.
And then see whether to go into this later.
Lordship, please, Lordship. So I'll just give the reference from my written submission, and then without reading minutes, I'll make the argument. Just give me the page from my written submission. Page 22 onwards, minutes.
Let's read that and see how you have formulated it.
Yes, minutes. Page 22, F. Meeting the respondent's case, whether the present case falls within the ambit of Article 194(2). And before that, Millets, I just want to draw attention to Article 80 of the Constitution, Millets. Dealing with Millets, the Council of States, the Rajya Sabha. 84, subclause 4. The representatives of each state in the Council of States shall be elected by the elected members of the Legislative Assembly of the state in accordance with the system of proportional representation by means of the single transferable vote. Therefore, voting in the Rajya Sabha is one of the duties of an MLA enjoined by the Constitution, not by the Representation of People Act. So the argument is going to be, where is the scope for saying that this voting is not that voting? Whether it's on the floor of the house or whether it's in the adjacent lobby. And that is why the distinction which I drew while reading the language of 105 and 194 also. Legislature is used separately, House of Legislature is used separately for authorizing publication. But otherwise, legislature is a compendious term. Legislature is something which is in permanent existence as an organ of the state, just as the judiciary is in existence and the executive is in existence. So therefore, legislature doesn't mean house of the legislature. So if in his capacity as a member of a legislature, he is constitutionally enjoined to vote, then he has all the protection of Articles 105 or 194. And minutes. Page 23 minutes. First part with paras 30 and 31. Para 30, we deal with the sheer logistics of voting. It is in a lobby. In fact, this has also been, this particular vote, and we have given minutes the report of the returning officer, it is in a lobby of the state legislature. How do you divorce it from the chamber of the legislature? This voting has taken place in the Jharkhand legislature, factually. And then minutes, a quick comment minutes on the cases which they have cited. One is where the question was whether someone who has been elected to a state assembly but has not yet taken his oath as a legislator, whether he can vote in a Rajya Sabha election. That was the question. And in that context, holding
Yes.
it was in that context, while holding that his vote was valid, he was entitled to vote, that this court said voting in the Rajya Sabha is different from voting on a bill as a member of the House, and that Mr. Sukul's vote would be valid. No question of immunity or privilege arose. Contrary to the submission made by the Union of India, the facts of the case are relevant. You can't look at the statement of law in the abstract. It arose in the context of this factual submission. Similarly, Madhukar Jaitley's case minutes. Facts are not clear from what is reported minutes, but again, it followed P. N. Shukul in this context. And coming minutes, the sheet anchor
Deep Nair.
of both the Attorney General submission and the learned amicus submission, which is Kuldeep Nair, so clearly distinguishable on a reading of the mere facts of the case minutes. Kuldeep Nair challenged two amendments. One is the domicile requirement, domicile in a particular state before you could stand for the Rajya Sabha from that particular state. So this led to very unusual situations. It's a matter of, it's a historical fact, that a distinguished Prime Minister of this country had to be a resident of Assam to be elected to the Rajya Sabha. This amendment did away with it. First part, this Honorable Court held it to be valid. The second was with regard to secrecy of ballot in a Rajya Sabha election. That was sought to be done away with, to do away with, or at least mitigate or reduce the evil of corruption and floor crossing, consequent floor quashing in the matter of elections to the Rajya Sabha. So, in the context of the submission, that secrecy of ballot is of the essence of voting. This Honorable Court held, while upholding that amendment, that this is not legislative voting for the Rajya Sabha, and that this amendment is valid, intended to cure a larger evil. Where was the question of immunity or privilege involved in any of these cases, and how are these cases being cited against me to say that 194 immunity does not inure to my benefit? So, it's completely distinguishable. But if this is to be read as a ratio of Kuldeep Nair, then it doesn't have to be part of the order of reference. I am before a bench of 7 learned judges, and I submit that if this is what Kuldeep Nair means, and says, then Kuldeep Nair is plainly wrong. But your lordships don't have to go to that extent, because Kuldeep Nair was in such an entirely different context.
Yes.
I conclude, Millets, by earnestly appealing, my lords, not to interfere. The carefully considered, well-reasoned judgment, a judgment which weighs the pros and cons, a judgment which is not unconscious of morality, but still gives plain effect to the words of the Constitution. No ground whatsoever has been made out for your lordships upsetting that view. I'm grateful for patient hearing.
Thanks. Thank you, Mr. Ramchandran. Thank you so much, Mr. Ramchandran.
So he giving me a photo to leave the court. How he can ask me that I have the locus or not, sir? This court have to
Anyway,
say that I have the
these
locus or not.
discussions and parleys at the bar are never made a grievance of before the court, Mr. Counsel. There's some tradition, there's some, exactly as Mr. Shankanayan says, these are privileged.
Sir, he is the second highest officer of the court and he
That's all right.
should maintain the decorum of the court.
All right, that's all right. This is not a subject matter of this reference, yes.
So, can- Wait, please, Your Lordship.
I didn't want to interrupt in this matter. It is not my dignity to interfere. That's why. But what was said is to offer a seat was also assisting me.
Sir,
And so
that
just-
sort of-
just-
1 second, sir. 1 second, sir. Mister, the Attorney General is on his feet. Please
We
observe
just
some
asked him-
dignity of the court. You must observe the dignity of the court. The Attorney General has a right of audience. He is speaking. He is the senior most member of the bar. He's addressing the court. Allow him to say, allow him to speak. Yes.
We just asked him whom are you representing. That's about all. I think we should have asked. You could not have asked that question. I think we are wrong. That's about all.
All right, we'll leave it at that. We will leave it at that now. That's all right. Mister, we'll leave it at that. We are not going to hear you on this. Leave it at that. Yes, Mr. Patwalia.
May it please, Your Lordship. Not actually, in my respectful submission, what is really essential for Your Lordships to see is what is the object and what is the purpose for which this immunity has been granted under Article 105 of the Constitution. Because according to me and according to the law as I have understood it, after P.V. Narasimha Rao and even on the international arena, the object is not to give protection to an individual from ordinary criminal laws. The object instead is to protect the integrity of the legislative process by ensuring the independence of the individual legislature. And once that be the object, the view, of course, of Justice Agarwal, according to me, is the correct view. And unless there is participation in a legislative process, there is, in my respectful submission, no question of the immunity kicking in. And therefore, that para which was read, according to me, gives the correct enunciation of law.